members of the committee, ladies and gentlemen, my beautiful children, who must be thinking, por fin, mommy. My dear family members who are here today, everyone, welcome. Thank you for joining me in this very special and very nerve-wracking occasion. Let me start by asking how many of you here have enjoyed or are enjoying the privilege of being legally married? If you can just raise your hands, please. And how many of you think that over time, marriage has evolved? And how many of you believe that two consenting adult human beings should be free to legally marry, not religiously marry, but to legally marry the person they love and are committed to? And do we all agree that homosexuality is part of humanity? And I'm very happy to see so many hands go up here today, especially considering that here in Aruba, the current, not only legal, but also political opinion that dominates is that marriage should be a union between a man and a woman. And if you look at the cartoon up on the screen, we here in Aruba are standing right next to this gay couple, although some are setting up camp here, and others are even being a step further down. And if you could title their stuff, it would read Abomination. Today, I will talk to you about the fundamental right to marry for same-sex couples, and I believe this topic could not have been more relevant today. As most of you here know, Parliament of Aruba is currently debating, I believe even as we speak, pending changes to Book 1 of our Civil Code, which pertains to family law, and there's an amendment being presented by a member of Parliament to introduce some sort of legal framework for same-sex couples. This is what is called a civil union or a civil or registered partnership. And considering that currently people who are in a stable and committed relationship lack any kind of legal protection or legal recognition. So of course, this issue, the idea of two people of the same sex getting married, is quite controversial, politically sensitive, and it can be explored in numerous ways. What sparked my curiosity was last year's landmark ruling by the United States Supreme Court, in which it basically legalized same-sex marriage in all 50 states. So what I wanted to find out was how come the European Court of Human Rights, well known for its progressive protection when it comes to human rights, did not find such an obligation for its 42 member states to legalize same-sex marriage. So I embarked on what is called a comparative legal pursuit, and this exploration was guided by three main research questions. And the first one asks, what are the main similarities and differences between the two different approaches when dealing with the same issue? The second research question is a more important one and tries to find out why there's such a difference in approach, even though it's the same matter, right? And the third and final question is closely connected with the whole purpose of conducting comparative research and asks what we here in Aruba can learn from these two different ways, two different traditional modes of dealing with same-sex marriage. So the two cases that were compared, the first one most of you may have heard of is Obergefell versus Hodges. And in the background you can actually see the couple whose name the case carries, which is Jim and John. He's actually, he was terminally ill, suffering from ALS, and he died a couple of months before the ruling. And they got married on a tarmac on an airplane because the state of Ohio did not recognize their marriage, or they did not allow marriages. So the case involves 14 same-sex couples, all applying for the right to marry. And the question was whether states could deny same-sex couple the right to marry, and whether states can deny recognizing legally performed marriages out of state. And the second case comes from Italy, and it involves three same-sex couples, all also seeking either the right to marry or some sort of legal recognition, be it a civil union or a civil partnership. And the answers. So for the main differences that were found were the most self-evident one has to do with the outcome, of course, in these two cases. And the case of Obergefell, the United States Supreme Court held that states cannot deny same-sex couples the right to marry, that they enjoy this right in every state, and this is a right guaranteed by the US Constitution. So by this ruling, the United States Supreme Court basically invalidated all state laws that kept same-sex couples out of the institution of civil marriage. And as for the Oliari ruling, it's quite interesting. As most of you know, it did progress on interpreting Article 8, which provides protection for family life by stating that Italy had basically violated its positive obligation to provide some sort of legal protection for same-sex couples. And as for the question on the right to marry, the court actually dodges this question and sort of finds that it will not analyze this based on the article of marriage. And the next main difference, of course, has to do with the choice of provisions. The 14th Amendment, of course, without this 14th Amendment, this ruling could never have been possible, considering that the Supreme Court found that, in its opinion, that the decision to grant same-sex couples the right to marry was primarily grounded in the liberty clause of the due process of the 14th Amendment. And it held that that there is a fundamental right to marry, and that this is based upon the fundamental liberty to choose who to marry, and this includes choosing to marry someone of your same sex. So this very broad, open-ended, general language, not specifically defining the term marriage or any specific listed right, provided the space for the interpretation of this liberty aspect. And as for the choice of provisions, the European Court of Human Rights, like I said, sort of dodges the question. The applicants all invoked Articles 8, Articles 12, which protects the right to marry, in conjunction with Article 14, the right protecting non-discrimination, and the court refused to engage in analyzing the articles of marriage in relation to discrimination by stating and referring to its previous opinion about this as being left to the decision of each individual member state, and instead finding a violation based on Article 8 by stating that Italy had no prevailing community interest to not provide same-sex couple with some sort of legal framework. The final difference has to do with judicial philosophy, and here we can just see that the American court practiced what is called judicial activism by making sure that it safeguards the rights and from the oppression of the majority, and so the people not need to wait for the democratic process. And the European Court of Human Rights instead practices what is called judicial restraint, sort of not wanting to give its judgment in the place of the judgment of the national authorities of each state. And of course, the main similarity is in the method of interpretation. They both apply what is called a dynamic interpretation. And this basically means that they see their judicial instruments as living, growing instruments. In the American doctrine, it is called the concept of the living constitution, and in the European court, it is called the evolutive interpretation. So this means that the document is interpreted according to societal changes and new meanings and understandings. In answering the second question, one of the main explanations has to do with the fundamentally different roles that each court fulfill in their respective legal system. In the European Court of Human Rights, European human rights system, the European Court, based on the subsidiarity principle, sort of fulfills the role of a secondary protector of the protection of human rights. So the one who is first called, primarily responsible for the protection of human rights, is the member states themselves, because they are considered to be better equipped. And so the Supreme Court's role is to provide individual relief in very specific circumstances. And instead of a more constitutional role of providing sweeping statements of principles. The Supreme Court, as you know, is a constitutional court, and by design, its role is to protect. Whenever there's a fundamental right involved, it automatically is called upon as the supreme interpreter to sort of give the contours of these rights. So it has that constitutional legitimacy. As for the second aspect, like I mentioned, the 14th Amendment has been, of course, very crucial. This is one of the most open-ended amendments, and providing a wide range of possibilities for especially minorities like women, people with disabilities, and people of sexual minorities to find some sort of protection, in considering it does not give specifically defined rights. So ample space there. The final clarification for this difference has to do with, in contrast to the European courts, where we don't even know the names of the judges or their ideological affiliation. The American Supreme Court, we all know the 9 judges by name, by their ideological leanings, and this majority opinion was a 4-5 vote, and the determining vote was casted by Justice Kennedy, which is not as ideologically rigid, so he went and took a side with the liberal wing of the court. But had he been a more conservative judge, or had the composition of the court been more conservative, the dissenting opinions would have been the majority opinion, and vice versa. So now to our last question, ask what we here in Aruba can learn from these two judicial ways of dealing with the issue of same-sex marriage. And of course, the ultimate purpose of any comparative research is to sort of, open up our capacity for self-reflection, to be self-critical, to dare to ask difficult questions. And the question is, we human beings, unlike Newton's apple, we can, make a decision, we have a choice. And are we going to sit and wait for intervention, considering that there might soon emerge a European consensus that sooner or later would sort of find this fundamental right that needs to be protected in all European member states, and are going to wait for this to sort of get imposed on us? Or are we going to tackle this issue by ourselves? I believe we can tackle this issue, and the way to do this is through what is called a civil discourse. And a civil discourse is basically having a conversation to improve understanding. Dare to have a conversation about things that we disagree deeply about, but are nevertheless open to listening to each other's opinion. And not by excessively persuading or personally insulting, but purely to increase understanding. And so I think there is an important role here for the University of Aruba to fulfill in sort of leading the intellectual debate and providing a platform, be it through critical commentary, critical scholarships, or publishing articles on their social media sites, providing media with information in accessible language, and so forth. There are many creative ways to sort of create and ultimately elevate our local debate. So what I have given you here today was a very highly abbreviated version of my thesis. It's of course 60 pages long, a lot of excruciating details in there, but I would like to invite all of you to read this and to deepen your understanding and hopefully join and especially elevate the current local debate by asking ourselves whether we here in Aruba should legally recognize the fundamental right to marry for same-sex couples. And I thank you.
Dankjewel voor deze inzetting. Dan zou ik graag als eerste het woord willen geven aan het buitenlid van onze commissie, mevrouw Nijgens.
Good morning, Amy. It took only a couple of hours to read your thesis. It was very interesting and well written. Want to congratulate you for that. This matter couldn't be more relevant as today the Parliament has to decide whether or not it introduces a legal framework for same-sex couples to formalize their relationship. I have 4 questions for you, if you don't mind. We live in a democratic constitutional state. This means we have to obey to the rule of law written in our constitution. In this matter, for example, is Article 1 very clear that people has the right to be treated equally. Our parliament, as the highest organ in our country, has to defend and respect this right of every citizen. What do you think then should be the role of our parliament in this matter? And even so, if a religious parliament is chosen by a majority, is it legitimate in a democratic state that it opposes the constitution and stands against equality?
I believe, first of all, it's important to be clear about what we are talking about. What we are talking about here is legal marriage, which is marriage as seen with its legal consequences. This has nothing to do with religious marriage, and therefore, of course, religious churches are free to design their own idea of religious marriage according to their own rules and beliefs, and this is also guaranteed by our constitution and the right to freedom of religion. And it's quite interesting because I took an angle, a human rights angle, and what I came across, what I found out is that basically when it comes to certain rights that are called fundamental rights, which are rights that we find that are so important that we have to keep these rights out of the ballot box. So we entrench them in constitutions most of the time, and in treaties and international organizations where people agree that these represent fundamental and deeply held values. And the 2 sort of basic core values underlying all human rights is equality and dignity. And so that sort of is the measurement of what it carries on. And of course, members of parliaments should do well to obey our constitution. That's of course necessary. But I would say that the religious arguments are not valid, that they enjoy their freedom of religion, but they also have to understand that legal marriage, who holds the key for legal marriage? It is the state. And when it comes to the state needs to treat all its citizens equally. And 2 of my premises in my thesis was that the elimination of heteronormativity, which basically expresses the superiority of heterosexuality above homosexuality, needs to be eliminated in our marriage laws. And there's research suggesting that this will provide equality for our fellow LGBT citizens. That's one. And the second has to do with marriage providing social inclusion for our fellow LGBT citizens. And what I argue is that we should eliminate this heteronormativity inscribed in our laws, because we want our laws to not be only tools that serve heterosexuals, but also our fellow people who are not heterosexual. We want our laws to be inclusive. We want our laws to be in accordance with humanity. We want our laws to evolve in accordance with new understandings and new insights as we come to know more. So I believe Parliament should definitely hear this call, the fundamental rights that they should be protecting as members of Parliament. And there is no denying that it cannot go against this by voting, even if it's a deeply held religious belief. They should always protect our Constitution.
Question number 2. Do you think we should do a referendum on this matter? And if so, does a referendum regarding this matter fit in our constitutional system, which is a democratic representation?
That's also an interesting question. I think first of all, we need to establish what kind of referendum we have in Aruba. I believe it's called a Thesis, which is a consultative referendum, which basically gives advice to Parliament. So members of Parliament who might be calling for this referendum to dodge their responsibility to vote, this is not going to help, because a consultative referendum means that the law needs to be passed first. And before it comes into effect, there are calls for a referendum to be advised upon the law. So they would have to stand either pro or against this specific law. And before it goes into effect, they should consult. I think that's the way the referendum works as one. So that will not be sort of a way that they could like avoid this and throw it on the majority. The second point is, as you know, referendums involve campaigns. And I'm trying to imagine what kind of message the people who are against same-sex marriage will come up with. I believe this will create a platform for homophobia or for hatred, and people will feel very comfortable to sort of, I mean, I wouldn't want my children to look at billboards that instill sort of homophobic messages. On the other side, it would also present an opportunity for transformation if those that are in favor of same-sex marriage sort of come around this important cause and mobilize and get organized and get the funding to come up with this campaign and sort of elevate, you know, the understandings and insights, bring out this message to people. This would sort of, I think, be also an opportunity. But on principle, I would be against a referendum because I believe there's a whole reason when it comes to a fundamental human right. This should be kept away from the ballot box. The whole idea is that this is sort of something that, especially when it comes to minority, is at risk of not being respected because it's not popular. And the whole idea of fundamental rights is that we guarantee this, and we do not put it at a vote. That's not where fundamental rights are decided.
Very good. Question number 3. What if the Aruban Parliament doesn't endorse the proposed amendment, civil union for same-sex couples, and leaves it up to the judge? What do you think the outcome of his judgment will be, considering the Oliari case, the fact that same-sex marriages are being registered in Aruba for almost 10 years now? As a result of the Yrausquin-Roos case, and in the light of Article 1 of the Aruban Constitution, will Article 31 of our Civil Code be rendered invalid, thus opening the possibility for same-sex couples to marry in Aruba?
That's also a very good question. So in the case of Oliari, I think that is definitely, when I wrote this thesis, it wasn't really clear as to the effects, but now we know more. And one of the points was that this could not be setting a new European standard because there were two context-specific arguments that had to do with Italy. This was that there was official polls, sort of, the official polls were saying that the majority was for, and there was numerous calls by the Constitutional Court of Italy to sort of tell Parliament to move and change its laws. So they said, you know, this makes it practically a context-specific case that would not present a general sort of standard. However, in the concurring opinion, I believe they stated that when the court finds that there is a positive obligation, it's sort of conceptually impossible to sort of limit it with contextual aspects. But I definitely believe that the aspect of registration increasing, and not only that, we as part of the kingdom also have a discrepancy. And we can also sort of bring forward the argument that our fellow Dutch citizens in regionally different place do have the rights, and we do not. So that would also be thrown in, I would say. But if I look at the Oliari ruling, I believe personally that now we are in violation of Article 8 of the European Convention of Human Rights. And by sort of, if Parliament accepts this law, we would then avoid future decisions against Aruba by the European Court of Human Rights, which, by the way, in the Oliari ruling, gave all the couples €5,000 rewards. So these are all aspects to consider as a country. And however, the judge would not invalidate, I believe, because the article says that marriage is between a man and a woman, and the European Court of Human Rights does not have the power to invalidate laws. it will sort of rule that they are in violation with higher law and that they should amend their laws accordingly. And this will then be overlooked by the Committee of Ministers of the Council of Europe to make sure they actually provide relief based on the ruling.
But do you think there is another issue here, the inequality, like a gay couple has to pay a ticket to travel to Bonaire, and then they will come and register in Aruba, and that's an equality.
I personally think it's ridiculous, but however, this needs to be battled, and I would definitely volunteer to come up with ideas and strategies, because it's not only about social and political activism, not only about stimulating the intellectual debate, but also about strategic litigation. And I believe I've learned that there were a couple who tried to register and this was denied. I think that's a great step forward to sort of channel those possibilities to get your right where you should be getting it.
Okay, the last question. In the final page of your thesis, you wrote that the University of Aruba has a cardinal role in civil discourse to elevate the quality of the debate in human rights. I think the same. I think that the University of Aruba not only has the task to educate and form its students, but also has the moral obligation to educate and inform the public in general. How do you think we can contribute or stimulate the University of Aruba to perform this important and essential role?
I'm glad you agree, and I believe as maybe future alumni, we could start a fundraising. No, definitely it's important for the University of Aruba, not only because it's an only academic institution with such authority, credibility, and sort of reflecting, independent thinking. It's important because the University of Aruba can sort of provide the platform for civil discourse and making sure that, fundamental rights are not just to be considered as a legal obligation or academic abstract concepts, but to make sure that through this civil discourse, actually minds, hearts, and souls are transformed. I think that's important because that's the only way that we can guarantee, in a durable way, that our laws are in accordance with fundamental rights, which ultimately is a reflection of our humanity. I think we all here can contribute to make sure in one way or the other we can help University of Aruba. I mean, with social media nowadays, we can live stream anything directly on anyone's Facebook page. And there are many ways we can contribute by sort of legal scholarship, giving lectures in accessible language, like I said, in Pavimento, opening up the university not just for the intellectual crowds, but for the people of Aruba. And like I said, it has to be in a way that people are sort of enticed to participate, that we hear each other out with the purpose of understanding, not with the purpose of necessarily persuading, but sort of opening up, facing ourselves, facing our prejudices or built-in biases. And there's so many things that through this honest and open conversation we can achieve. And so if you organize a fundraising, I'm willing to help out.
Amy, Mashadaki, bonita escreve.